please see under Article 371. These are all appears to be powers under 371D, but all COs mention it as 371. Maybe making a little broad source of power of the Constitution of India. In following consultation with the government of Jammu and Kashmir, the President issued the so-and-so order 1952 modifying Article 54 and 55 of the Constitution insofar as it applied to the state of Jammu and Kashmir. By this CO, for the first time, President recognized the Constituent Assembly as the Legislative Assembly for the purpose of election of the President of India. Your Lordships would note, when Constituent Assembly of Jammu and Kashmir was formed, obviously there was no Legislative Assembly because that was yet to be a part of the Constitution to be framed. So as to ensure that they do not lose their representation in election of the President, this CO was issued that you will be treated as Legislative Assembly also. Your Lordships would find at the end of this chronology, 370 has been applied in kind of a floating way. Whenever, my lord, it is required to use the word interchangeably, it is logically so used, and whenever any word has become OTOs, it is replaced by its successor. Look,
at that point, there was no legislative assembly at all.
At all, correct.
Therefore, they had to make this CO
correct.
To read that instead of the word legislative assembly shall also include a reference to constituent assembly. Because at that point, there was no legislative assembly.
My lord, exactly that is where, my lord, I would respectfully drive it. When there is no legislative assembly, a constituent assembly, the President has said that now it would be treated as legislative assembly. But that I'll come little later. But it has been used, my lord, kindly see there are two prominent features in COs which comes up.
Yes.
A, it has been used in a floating way, some words used interchangeably. And second, and most important for my purpose, whenever a word in Article 370 becomes OTOs for that post not being in existence, that body not being in existence, it is immediately replaced by its successor. Sadr-e-Riyasat is replaced by governor, etc. Now, my lord, your lordships may come to the next date, 20th of June, 5th. There was a letter, my lord, referred to by Mr. Gopal Shankar Narayan, where Dr. Rajendra Prasad, the then Honorable President of India, writes to the Prime Minister, Honorable Prime Minister Nehruji, that this can be used only once, etc. That is being used, that can be used, my lord, in buttressing the arguments which I am also advancing. But we also got, my lord, the response of the Honorable Prime Minister. I'll put it, my lord, when that fact comes, my lord. And thereafter, the same Honorable President issued, my lord, order under 370 sub Article 3 also. So, my lord, literally, actions speaks louder than words. That was, my lord, the understanding, but the understanding was that it is so drastic a provision that use it only once. It's an self-extinguishing provision. That's my lord, the tenor of that order. Later, Lord, while the Constituent Assembly of Jammu and Kashmir was in session, Lok Sabha also continued its session. In New Delhi, as per Constitution of India, during one of the Lok Sabha debates, Lord, please see, my lord, how our Parliament understood Article 370. Lord, the purpose is to satisfy your lordships that Article 370 is not just stated to be temporary. Legislative Assembly debate says it is temporary. Even during the subsequent parliamentary procedure also, everyone treated it as a temporary measure. But only for that, this is N.C. Chatterjee, Lord, incidentally, he was the counsel in Premnath Kaul judgment, N.C. Chatterjee. He must be a member of parliament also. Lord, I'll just read the underlined portion. I maintain and I say that with all earnestness that under the law, under constitution, accession to the dominion of India under section 6 of the Government of India Act, as amended after the Indian Independence Act, was final and irrevocable, and there ought not to have been any question of plebiscite. I maintain that accession is final and irrevocable. Under our constitution too, Kashmir is an integral part of India. Under Article 1, the Indian constitution consists of federation of states and it is a part B state. There cannot be any going back on that. But the unfortunate thing is that the Constituent Assembly is doing something there which is against the spirit of our constitution. I know my honorable and learned friend Dr. Kaju will point to me Article 370 of the Constitution. Article 370 is part of Chapter 1221 and it deals with temporary and transitional provisions. Then, Dr. Mukherjee, in a democratic federal state, the fundamental rights of citizens of one constituent unit cannot vary vis-a-vis the citizens of another unit. Are not people of Jammu and Kashmir entitled to the fundamental rights that we have given to the people of India minus Jammu and Kashmir? There is no scope for varied constitutional patterns, disparities as between one federating unit and another. The legislative or executive authority of the units in respect of the states will be coextensive with the similar authority in and over the provinces to certain adjustment during the transitional period, the fiscal relationship, etc. Then, my Lord, Pandit Ji, as the Prime Minister and Minister of External Affairs, Lord, response. So, Kashmir obviously is a constituent unit of the Federation of Union of India, but a difference has subsequently arisen. You please remember that, not originally, between Kashmir and other states, because subsequent to the earlier accession, the other states have become integrated, more which Kashmir has not and could not in the circumstances as I have tried to point out. But nevertheless, it is a full constituent unit of India. Various things flow from it, various consequences. Consequences, for instance, in regard to the President of the Republic. The President has certain authority which he exercises on behalf of Republic, and wherever the constituent unit may be, the President will exercise that authority in that measure. But come to the last line. But the President's ultimate right has to remain for a constituent unit of India. That irrespective of 370, the President of India's right, which he exercises on behalf of the Republic, which he exercises on behalf of we the people of India, must remain as a plenary power without any fetters. My Lord, that's how the Parliament understood. My Lord, thereafter, my Lord, your Lordships would come to, my Lord, page 52. First two dates your Lordships may skip. My Lord, during the Jammu and Kashmir Constituent Assembly debates also, my Lord, I have quoted, but I may, my Lord, just paraphrase it and proceed further. Lord, it says, every member says, this is temporary. They also understood it to be temporary. My Lord, I am not laboring on the point right now why it is temporary. The point is, which I will ultimately make, despite full knowledge that Article 370 is a part of the Constitution, despite having accepted in the Constituent Assembly debates of Jammu and Kashmir that it is temporary, they chose not to make any recommendation under sub-article 3. My Lord, that's a separate limb, and my Lord, I'm just flagging it here. Kindly see, my Lord, highlighted part. This assembly came into being because of section 370 of the Indian Constitution, and it was because of the section that we enacted such laws as were necessary for our society. So, my Lord, they understand that its very source of existence was Constitution of India. But kindly come to page 53, third. Lord, this is third date, 15/11/52. Lord, this was the first use of Article 370, sub-Article 3. So kindly note this. Yes, my lord, kindly allow me, my lord, to point out, my lord, this might appear to be striking because it is striking. It should never have been at the first given and should never have been continued. The effect of 370 with 367 or any provision of the Constitution is that by an administrative act of the Honorable President and the Government of the state, any part of the Constitution can be amended, can be altered, can even be destroyed and not applied, and new provisions can even be created in Constitution of India. 35A, I'll come to it. Article 35A was created, which is a part of Constitution of India, only to be applied to the state of Jammu and Kashmir. That's why, my lord, this 371 route and 367 mechanism has been used more than once because 370 permits it. It stopped, my lord, only after 5th of August 2019. Otherwise, any provision, any article, my lord, it was placed much at a higher pedestal, as my Lord Justice Call rightly pointed out, than even a basic structure. Please see, my lord. Constitution application to Jammu and Kashmir, Order 52, was issued by way of the state presidential order issued under Article 3701D. The first exercise is 3701D. The term Raj Pramukh, used anywhere in the Constitution of India, Jammu and Kashmir being a Part B state, was replaced by Sadari Riyasat of Jammu and Kashmir. My lord, because in Jammu and Kashmir, Raj Pramukh was not there, Sadri Riyasat was there. So wherever one authority ceased to exist, it was replaced by the successor authority. Now the second part which is done, similarly, with a CO 44, there are two COs, my lord. Explanation to clause 1 to Article 370 was modified by the President in exercise of his powers under Article 370, sub-Article 3, on the recommendation of the Constituent Assembly. My lord, because there, at that point of time, Constituent Assembly was in existence. So the proviso to sub-Article 3 could be operated. Therefore, it was so recommended, and the President added these words: the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadri Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in force. Well, the purpose of pointing out is that 370 has continuously been evolved depending upon the need of that situation at the point of time. Earlier, it was Maharaja. Since Maharaja ceased to exist and Sadra Riyasat came, it was modified using 370 sub-article 3. And since Constituent Assembly happened to be functioning, it was with recommends. I'm sorry. Now, Lord, your Lordships may kindly come to page 54. CO 48, Lord, that is 14th May 54. Lord, several other provisions were applied, but your Lordships may right now only mark fundamental rights. How it was applied is really shocking, and I'm using that word consciously. What was not applied is also interesting at the foot of page 54, which continued not to apply till 5th of August 2019. That is, my lord, at the foot your lordship gets, my lord, notably. Sorry, I am on page 54. My lord Justice Khanna may see.
Yeah, I've got it.
Lord, fundamental rights just mark that they were applied. But what was not applied, notably, it did not apply the following parts at all. That is, directive principles of state policy, the states in part B, and scheduled and tribal areas. Tribal areas and any tribal reservation, etc., never applied in the state of Jammu and Kashmir till 2019. Now, preamble was applied. Lord, your lordships are aware, preamble is not treated to be a part of the constitution, and therefore, my lord, it is separately applied. I am not repeating. The word socialist and secular was not applied. Of course, they have put it in the directive principles. But directive principles are amendable by legislature. Your lordships are on page 50.
Yes.
Lord, kindly come to foot of page 55, because this, according to me, Lord, as a student of law and as a citizen also, Lord, is something very, very serious. Other notable features, my lord, by this CO, what was done? It provided for a separate provision for permanent residents of Jammu and Kashmir in Article 7. That is, my lord, citizenship of Indian Constitution, by inserting 35A.
Yes.
Then it removed references to scheduled tribes from Article 15, Sub-Article 4. So, one, you alienate those who do not fall within the artificially created definition of permanent residence. Second, you alienate those who belong to scheduled tribe. Then, this is important, Article 19, 22, 31, 31A and 32 were applied with some modifications, and I'll show which modification. Surprisingly, in Article 19, please note this, Malod, this is something really shocking. And for 25 years, this continued. I am arguing this matter not from the point of view of center succeeding or state succeeding. How 370 operated on the people of Jammu and Kashmir because of 370. That's what, my lord, my attempt is. Surprisingly, in Article, I'm sorry.
Yes.
Surprisingly, in Article 19, the following sub-article 7 was added by way of modification which remained till 1979, for 25 years. And what was that?
Yes.
Article 19, sub-article 7, as applicable to the state of Jammu and Kashmir, the words reasonable restrictions occurring in clause 2, 3, 4 and 5 shall be construed as meaning such restrictions as the appropriate legislature deems reasonable. The citizens apply fundamental rights against the state, and now the legislature would decide what are the reasonable restrictions.
Other provisions of Part 3 were applied without any modification.
There is a modification.
35C is there.
35C, my lord. And that is more draconian, my lord, if I am permitted to say so. Because that directly affected the personal liberty of the entire population of Jammu and Kashmir.
Preventive detention.
Preventive detention. 21 and 22 would not apply. But it's unthinkable in any constitutionally governed civilized society that Article 21 and 22 would not apply. Please see, my lord, Article 35C was added. India's constitution was amended by the government of India in consultation with the state government, adding this sub-article. Lord, see, no law with respect to preventive detention made by the legislature of the state of Jammu and Kashmir, whether before or after the commencement of the Constitution Order 1954, shall be void on the ground that it is inconsistent with any of the provisions of this part, but any such law shall, to the extent of such inconsistency, cease to have effect on the expiration of 5 years from the commencement of the said order, except as respects things done or omitted to be done before. Lord, this 5 years became 10 and thereafter it became 15. It continued till 1974. And my lord, most interesting part which I found,
Mr. Solicitor, you are appearing for the government of India, which did all this.
yes, my lord, I am saying.
In constitutional theory, the government of India
Government
is
of
a,
India
is a perpetual
is a
entity.
succession. My lord, the government of India has a right to say that this ought not to have been done and correct itself, which we did, and I am justifying that correction. I am not saying that government and this government. It's our government.
Because in constitutional doctrine, the government of India is one perpetual entity.
Perpetual entity with perpetual succession, my lord. And therefore, my lord, the justification, my lord, which I am trying to give is that the mistake of past should not befall on the future generations. And that's why what we did in those days, I am justifying, my lord, I am justifying our undoing it in 2019. Lord, one very interesting angle I found out, Lord, while researching this on this question. Lord, in Premnath Kaul, some person was, Mr. Kaul was, Premnath Kaul was detained under preventive detention law. He approached this honorable court under Article 32, challenging his detention. The learned Attorney General, then, my lord, appearing for the government, took the contention that 32 petition is not maintainable because it would lie only for violation of fundamental rights And for Jammu and Kashmir, Article 21 and 22 are not fundamental rights. Fortunately, my lord, the court did not go into that question and decided it on merits. I'm sorry, Sampath Prakash, not Premnath. That was, my lord, the position of the 35C. Fundamental rights, your lordships have said 21, 22 is the heart and soul of the entire chapter 3. That was not applicable. It could be dispensed with while making a law for detention. Then, my lord, 35A was added. Please come to, my lord, page 56. And this, my lord, if we were to believe, resulted in several consequences. You see 35A amended in Constitution of India only to be applied in one state of Jammu and Kashmir. Please see, madam. One artificial class was created. Notwithstanding anything contained in this constitution, that is Constitution of India, no existing law in force in the state of Jammu and Kashmir and no law hereafter enacted by the legislature of the state defining the classes of persons who are or shall be permanent residents of the state of Jammu and Kashmir or conferring on such permanent residents any special rights and privileges or imposing upon other persons any restrictions as respects employment under the state government, acquisition of immovable property in the state, settlement in the state, or right to scholarship and such other forms of aid of the state government may provide shall be void on the ground that it is inconsistent or with or inconsistent with or takes away or abridges any right conferred on the citizens of India by any provision of this part. A separate category of permanent residents was created, and any law which provides for this kind of special privileges would not be hit either by Article 14, Article 19, or any part of the Constitution. And that demarcating line from which date a person should be treated to be a permanent resident was, I think, 35. Yeah. Those
35A challenged on the ground that it violates the basic
The
structure.
35A, it is, there are 5 petitions pending.
No, but that's, before that it was never challenged.
They were challenged at the relevant point of time, could never be decided. I think, since long. Lord, kindly see, my lord, the impact of this. The cutoff date was, my lord, I am told 1927. So whoever came in Jammu and Kashmir in 1927 were permanent.
That's the law. What is the provision itself? It says it's not, the judicial scrutiny is therefore prevented because
Now, the impact was, for example, people from Jammu and Kashmir, people from Pak-occupied Jammu and Kashmir, Pak-occupied Kashmir, POK, were driven out, both Hindus and Muslims. But they were driven out in 47 during those raids. They are not permanent residents. They were not permanent residents till 2019. There were large number of Safai Karmacharis who have filed a petition, my lord, or intervention application, who were brought from other states to do, my lord, the manual work of cleanliness, etc. They are not permanent residents. They are not getting any of these benefits. Despite living for decades together, no person, my lord, beyond outside Jammu and Kashmir can acquire property, meaning thereby no investment.
from this point of view.
Yes.
I was just looking at the 1954 order, CO 48.
Yes.
That applied the entirety of Part 3
Yes.
and then made certain modifications. Therefore, Article 16 applied, Article 19 applied. But now see what happens. If you look at the CO, it applies Part 3. That is Volume 3. You get it at Volume 3, page
14 months.
page 14.
Yes.
Volume 3, page 14. But you bring in Article 35A, which creates an exception in 3 areas. Employment under the state government, 2, acquisition of immovable property, 3, settlement in the state, leave aside scholarships. So though Part 3 is made applicable, by the same vein, when you introduce Article 35A, you are taking away the 3 rights, 3 fundamental rights. 16(1), 19,
14.
and 16(1), then you are taking away the right to acquire immovable property, which then was a fundamental right under 19(1)(f) and Article 31. And third, settlement in the state, which is a fundamental right under 19(1)(e).
Right.
So though the Constitution expressly made the provisions of Article 19 applicable, which would include these 3 rights, and Article 16, by enacting 35A, you virtually took away the fundamental rights.
Employment is also right to life.
Right, but there's a direct right under 16(1).
Yes. No, employment is a separate right and would fall within separate category of right to life.
No, that itself was not taken away. What was taken away was employment under the state government. Because what 35A did was, it says conferring on such permanent residents any special rights and privileges or imposing upon any other persons, any restrictions. So it does both things. You can give special rights to residents and you can take away that right insofar as non-residents are concerned. Employment under the state government. Employment under the state government is expressly covered by Article 16(1), because 16(1) says there shall be equality of opportunity for all citizens in matters relating to employment under the state. That includes the union as well as the states. So while on the one hand, Article 16(1) was preserved, 35A directly took away that fundamental right and granted immunity to any challenge on the ground that it would deprive you of a fundamental right which is protected by 16. Likewise, 19. 19 recognizes the right to reside, settle in any part of the country.
Right to acquire property.
And then, property then was 19.
Now it is 300.
So all 3 fundamental rights were essentially taken away by 35A, which was brought in by CO 48.
It continued till 2019.
Power of judicial review was taken away.
Judicial review was taken. So it is beyond 9th schedule. Almost put at par, beyond 9th schedule also. And this continued till 2019, till the impugned resolution, impugned CO was passed. Therefore, my lord, I am respectfully urging that please look at the matter from the point of view of people of Jammu and Kashmir. Something which is impugned before your lordships is a constitutional exercise of power which confers fundamental rights, which applies the entire constitution, which brings the Jammu and Kashmir people at par with their rest of brothers and sisters, and Lord applies all laws which are welfare legislations, and I have the list which was not applicable to the state of Jammu and Kashmir. And the very unfortunate part is, and this is really, my lord, a troubling part, that till now the people were convinced by those, my lord, who were supposed to guide them, that this is not a hindrance in your progress. This is your privilege. You fight. Nobody can take away 370 from you. That is the most unfortunate part. And your lordships have, my lord, at least 2 major political, I'm not being political, major political parties before your lordships defending 370, including 35A. When your lordships ask, what did you lose out of it? There is no list. This is what the people rightly lost. They got their fundamental right 35A goes. They got their fundamental right 35C goes. And I will come to, my lord, several other, my lord, provisions which were working against the interest of the people, but they were convinced. Now they have realized what they have lost. Because now, because of 35A not being there, investments are coming. Now, because of, my lord, the law, I'll show, my lord, from the Reorganization Act, because of the policing being now with the center, my lord, tourism has started. Jammu and Kashmir traditionally didn't have much of big industries. They were cottage industries, small industries, etc. Main, Lord, the source of income was tourism. Now tourism has started. By now, Lord, 16 lakh tourists have come. New hotels are coming up, which gives employment generations for the two large number of people, right from Tangawala to Lord, officials. I'll come to that. So
in a manner of speaking, 35A is not a modification of Article 35. It is a creation of a new article in the Constitution. That's why I'll make it sufficient.
The
It's
scope,
not a modification at all.
the scope of expression, exceptions and modifications
That's right.
will also.
So virtually you created a new article in the
A
Constitution.
new provision.
That's right. It's not a modification.
it's not a modification. Therefore, I respectfully urge 35A is creating a new provision in Constitution of India only to be applied to Jammu and Kashmir. Now, my lord, if a lady marries outside Jammu and Kashmir, she loses permanent residency. There are several such things, my lord. People coming from West Pakistan who were, my lord, settled down from decades were not.
The first part was struck down by a 3 judges bench of the J&K High Court.
By the High Court, my lord. I'm sorry, I was not aware of
In
it.
terms of view, 3 judges bench.
I'm told their children will not get, whatever, my lord. That's
Now,
now.
those say children will not get it. It was a nebulous situation which was get.
Now, my lord, kindly come to page 57. And my lord, the argument was that why did you not consult ABCD? My lord, out of ABCD, ABC is proclaiming that 370 is our right. Official, that's the official stand. So leave it at that. Please come to page 57. Now, my lord, use of mechanism under Article 367 for the interpretation of Article 370 for the first time. But any provision of the Constitution can be amended by executive action or constituent action, my lord. Now, without bringing the parliament. Therefore, my lord, 367 is a legitimate use so long as don't apply.
into the constitution as applicable to the state of Jammu and Kashmir
Only.
by CA 48 of 1954.
Correct. So constitution was amended, which was 30, that was 370. You can amend the constitution or you can apply existing provisions.
Under
with-
370, a CO was issued, and which brought in a sense, 35. Right?
Correct. Now, my lord, page 57. But as I pointed out, whenever the situation required it, 370 remained floating. Whenever some changes were required, depending upon the circumstances, they were made through the mechanism of 367. 367 is an interpretation clause. So the interpretation was made. Now, please come to page 57.
Yes.
Sub-article 4 was added in article 367 as applicable to Jammu and Kashmir. This sub-article 4 is not applicable elsewhere. It's only for Jammu and Kashmir. For the purpose of this constitution as it applies in relation to the state of Jammu and Kashmir, references to this constitution or to the provisions thereof shall be construed as references to the constitution or provisions thereof as applied in relation to the said state. Then references to the government of the state shall be construed as including references to the Sadri Riyasat acting on the advice of his council of ministers, because by that time Sadri Riyasat had come. References to a high court shall include references to the High Court of Jammu and Kashmir. D. Please note this, my lord. References to the legislature or the legislative assembly of the said state shall be construed as including references to the constituent assembly. They were used interchangeably.
That time there was no legislative assembly.
At that time, there was no legislative.
No, it was, my lord, to be made immediately. Therefore, my lord, in advance, my lord, they must have made a provision. There was none, my lord. This is 54, so there was none. Because constitution was framed in 57.
So in terms of giving representation to the state in other forms, it would require Constituent Assembly to be interchangeably used so that till the Constituent Assembly finalize something, it would not.
No, my lord, another purpose is that till the legislature assembly comes, legislative assembly comes, somebody will have to make laws other than constitution. They were made. The Constituent Assembly after this functioned as a legislature of Jammu and Kashmir also. And they made other laws also. I have given the list.
Primarily to ensure enforcement of 370 articles of our clause 1, which power was vested with the legislative assembly, so they vested it with the constituent assembly.
Constituent Assembly, so that laws can be made by the Constituent Assembly. Otherwise, my lord, Constituent Assembly is not a law-making body in that sense. Of course, my submission is that Constitution of Jammu and Kashmir is at par with a legislation only. It's not, my lord, a kind of a constitution as we understand, my lord, as a document of governance. Comes to page 59. Look, these are the laws made. I'm not reading, it's not necessary. I'm sorry, my Lord Justice call is conferring. Lord, these are the laws which were made by the Constituent Assembly acting as a legislative assembly of Jammu and Kashmir. Page 59. Page 59, up to, my lord, page 60. But your lordships can consider noting here that exercise of mechanism under Article 367 to make changes in 370 is undertaken 4 times, which, my lord, I'll come periodically. And whenever some body was not available, the successor body was named. Can I? I'm sorry.
Yes.
I'm sorry. I thought my lord, the Chief Justice is writing.
Yes.
But this exercise or use of mechanism under 367 was directly in issue in Damnu judgment.
Yes.
And it is approved by, my lord, your lordships, my lord, speaking through
Yes.
the constitution bench. But then comes Puranlal Lakhanpal, my lord, I am not reading it because I don't think anything turns on that either for me or for the other side. It would not render any assistance. It just records the history, that's all, my lord, which we have, my lord, already given. Now, your lordships, my lord, kindly see page 62. The State Reorganization Act comes. It does 2 things. One, Part A and Part B states are clubbed into one called states. So Jammu and Kashmir ceased to be Part B, but it became a state like any other state. And Part C states became union territories. That is first. Sorry, C and D both became Andaman Nicobar was D. So A and B became states and C and D became union territories. We are not concerned with that right now in this matter. Second was the identity of princely states completely abolished. Till then, till 56, the Raj Pramukh was the erstwhile princely ruler. This was abolished. That now, henceforth, it would be the governor appointed by the President of India. The President who is responsible to the Parliament and the Parliament who is responsible to we the people of India. So now, no Raj Pramukh, who is the princely state. He can be appointed as a governor, that's one thing. Some of them were appointed, but not by virtue of they being a member of that lineage in the princely states. But this happened. But at this stage, Article 238 was repealed. Rather omitted, not repealed, it was omitted by 7th Constitutional Amendment. Your Lordship,
So, another thing.
Please come to page 63 only for one date it is relevant. I'm not reading anything.
Page?
Page 67, 63, 17/11/56, the constitution of the state of Jammu and Kashmir is framed. The document called Constitution of Jammu and Kashmir is framed. That's all. Thereafter, straightway, my lord, I have, my lord, given excerpts from the debates which essentially says that Jammu and Kashmir is an integral part of India. I don't think that is something which is my lord, required to be labored much. Therefore, I am not skipping.
Who realized that also?
Yes, my lord, therefore, I am skipping that. Please come directly to page 67, my lords. The second use of the mechanism under Article 367. Your lordships would recall, in the first use, the Honorable President said Constituent Assembly and Legislative Assembly are used interchangeably. But at this stage, the Constituent Assembly ceased to exist because the constitution was framed. Therefore, please come to my lord page 67.
This is CO 56, right?
Yes, my lord. CO 56 dated 26th February 58. Was required in 58 because of a constitution of Jammu and Kashmir being framed and constituent assembly ceasing to exist, and because of the state reorganization act. Please see, my lord, at page 67 bottom, D is deleted. He read reference to the legislature or the legislative assembly of the said state shall be construed as including reference to the constituent assembly of the said state. Because the constitution was framed, constituent assembly ceased to exist, and therefore, my lord, this clause was amended. And E, the term Raj Pramukh was replaced by the word governor because of the state reorganization act. Now, Raj Pramukh system has gone.
Yes.
Phraseology used was governor henceforth from this.
Yes, henceforth it was governor.
But the phraseology used to head of the elected government as prime minister did not cease with this.
I beg your lordship's pardon.
Chief minister used to be called the prime minister there.
Yeah, that went, my lord, after Sadr-e Riyasat itself. It became Sadr-e Riyasat. Prime Minister went.
Went after that. Only as a matter of sequence of dates I want.
Yes, yes. It became Sadr-e Riyasat, and thereafter, my lord, Raj Pramukh, and thereafter governor. Now it remains governor throughout thereafter. Now kindly see, my lord, page 69. I am skipping the rest, my lord. They are, my lord, kindly see, my lord, first page 68, Premnath call, the first judgment.
Yes.
It was more on the competence of the Yuvraj. And therefore, my lord, I believe it may not render
Can we
assistance.
just read that para?
Yes,
Can we just read
I'll,
that
my lord,
para?
please. The Supreme Court renders its judgment in Premnath Kaul versus State of Jammu and Kashmir. It's a 5-judge bench, my lord. The issue before the court was the validity of Jammu and Kashmir Big Landed Estate Abolition Act, which was enacted by the Yuvraj in exercise of powers vested in him under Section 5 of Jammu and Kashmir Constitution Act, 1996. Well, 1996 is somewhat here, 1939, the old constitution. The judgment discusses the constitutional history of the state in great detail and at the same time discusses the power of Maharaja under the previous constitution of the princely state. The question before the court was whether the provision of Article 370, sub-Article 1 till the time the Constituent Assembly of Jammu and Kashmir was in session affect the plenary powers of Maharaja in the matter of governance of the state. In this context, the court held that the act in question, which was enacted in 1950, would not stand interdicted by Article 370 and held that Yuvraj was competent to enact the act. The case effectively concerned the issue of legislative competence of Yuvraj when there is no constituent assembly of Jammu and Kashmir. But in these very proceedings, when there was a request for a reference to a larger bench, in this very petition, Lord, the 5-judge bench, Lord, speaking through my Lord Justice Call, exactly said this, that it may not have bearing on the either side. Now, my Lord, page 69. Now, my Lord, the integration of judiciary. Slowly, my Lord, some provisions came to be applied, truncated, some full, some modified, some with exceptions. But Article 222 was made applicable regarding transfer of judges. Earlier, my lord, till 60, the honorable judges of the High Court were not transferable by the Supreme Court. But the oath was prescribed, and till 2019, the honorable judges of Jammu and Kashmir High Court used to subscribe to this oath. My lord, please see. Oath or affirmation to be made by judges of the High Court. I, Sri So-and-so, having been appointed Chief Justice or a judge of the High Court of Jammu and Kashmir, do swear in the name of God, solemnly affirm that I will bear true faith and allegiance to the Constitution of the state. Though they were, my lord, under an obligation because of Article 1, and they were applying the Constitution of India. But the oath which they used to take was expressing their allegiance to the Constitution of Jammu and Kashmir state. Even the Honorable Chief Justices, my lord, who would be appointed there, my lord, would be taking this oath. That's it, my lord, nothing beyond. Now, your lordships may kindly come to Puranlal Lakhanpal judgment, my lord, where I would read only one para, my lord, of that judgment, because something turns on that, and I will show, my lord, Sampath Prakash thereafter, my lord. At this stage only, my lord. Please come to, my lord, Case Law Compilation, Volume 1. Page 24, my lord. Only para kindly see, my lord, in those
Case
days,
law
my lord, what used
compilation,
to.
which one did you say?
I'm sorry, my
Volume
lord.
one. Volume one.
Case Law Compilation, Volume 1, page, PDF page 24. But somebody wanted to stand for election to be elected to the House of People, that is Lok Sabha. He filed this petition. My lord. Please see, my lord, page 1 and 4. My lord, only two would be relevant, my lord. Am I with your lordships on page 5? My lord, 24? Premnath call, my lord. The petition challenges the constitutionality of a provision in the Constitution Order 54 made by the President under Article 371. The case of the petitioner is that he is registered as an elector in the parliamentary constituency of Delhi. As such, he has a right to stand for election from any parliamentary constituency in India. 6 seats are allotted to the state of Jammu and Kashmir in the House of People, Lok Sabha. Ordinarily, the election to these seats should have been direct election from the territorial constituencies in the states as provided by Article 81(1). And this is what was happening in rest of the country. But the President modified that article insofar as it relates to the state of Jammu and Kashmir by para 5C of the order in these words. Article 81 shall apply subject to the modification that the representatives of the state in the House of People shall be appointed by the President on the recommendation of legislature of the state. No direct election in Lok Sabha. It's like Rajya Sabha. And the contention was, the petitioner contends that the President had exceeded his powers when he made this modification, for he thereby substituted direct election to the House of People by nomination which he could not do. This, it is said, was a radical alteration. But please mark these words. Yes. Now, kindly, my lord, come to para 4. Court says even radical modification is permissible. But even assuming that the introduction of indirect election by this, my lord, your lordships have para 4, my lord, at page 25. May I read with your lordship's permission? But even assuming that the introduction of indirect election by this modification is a radical alteration of provisions of Article 81(1), the question still remains whether such a modification is justified by the word modification as used in Article 371. We are hereby dealing with the provision of a constitution which cannot be interpreted in any narrow or pedantic sense. The question that came for consideration in Delhi Law's case was with respect to power of delegation to a subordinate authority in making subordinate legislation. It was in that context that the observations were made that the intention of the law there under consideration when it used the word modification was that central government would extend certain laws to Part C states without any radical alteration in them. But now this is the ratio. But in the present case, we have to find out the meaning of the word modification used in Article 370 subarticle 1 in the context of the Constitution. As we have said already, the object behind enacting Article 370 subarticle 1 was to recognize the special status of state of Jammu and Kashmir and to provide for that special provision by giving power to the president to apply the provision of the Constitution to that state with such exceptions and modifications as the president might by order specify. We have already pointed out that the power to make exceptions implies that the president can provide that a particular provision of the Constitution would not apply to that state. If therefore the power is given to the president to efface in effect any provision of the Constitution altogether in its application to the state of Jammu and Kashmir, it seems that when he is also given the power to make modifications, please note, my lord, mark, that power should be considered in its widest possible amplitude. If he could efface a particular provision of the Constitution altogether in its application to the state of Jammu and Kashmir, we see no reason to think that Constitution did not intend that he should have the power to amend a particular provision in its application to the state of Jammu and Kashmir. It seems to us that when Constitution used the word modification in Article 371, the intention was that the president would have the power to amend the provisions of the Constitution if he so thought fit in their application to the state of Jammu and Kashmir. Thereafter, dictionary meanings, etc., is quoted. Lord, why I am reading this? Lord, Mr. Nafde urged that this is an obiter and therefore not laying down any law. Lord, in Sampat Prakash, subsequent judgment, again, my lord, the same Lord, numerical strength, 5 honorable judges, reproduces this para, relies upon it as a ratio. It's not an obiter. Let me directly go to Sampat Prakash so that this point is clear. This is not an obiter. This question directly fell for consideration. The petitioner wanted this honorable court to interpret whether there is any power of radical alteration or modification. And this honorable court said, you can even efface a part of the Constitution. Then obviously radical alteration is something which you can do. Now, Lord, in the same compilation, if your lordships can come, the next judgment, my lord.
27.
Yes, my lord. Please come to, my lord, page 27. This was a detention case. Please come to para 2. At page 28. Does your lordship not have them? I'll just read para 2. During the preliminary hearing of this petition, Mr. Ramamurthy, representing the petitioner, it was, my lord, a detention case. raised a ground that section 13A of the act, under which, my lord, the local act, under which the petitioner was detained, was ultra vires the constitution as contravening the provisions of article 22 of the constitution. That question was referred by the constitution bench to the court to a larger bench and came before the full court. On this occasion, the court held that in view of clause C of article 35 of the constitution introduced in the constitution in its application to the state of Jammu and Kashmir, the point that had been raised stood answered by the addition of this clause, and unless the clause itself was challenged, the point raised on behalf of the detainee did not arise. In this view, the reference was dissolved and the case has been heard by the constitution bench. They said that till you challenge 35C, obviously fundamental rights under 21, 22 are not applicable to a detainee. My lord, thereafter, my lord, your lordships may kindly come to page 29. So this takes care of Mr. Dwivedi's argument, Mr. Dwivedi for the petitioner. No, my lord, on this side also we have Dwivedi.
You have to argue anything.
Yes,
That's in a brotherly sense.
yes, sir. 29. The first argument, my lord, your lordships would find after, my lord, quotation of the section. The first argument was that this article contained temporary provisions which ceased to be effective after the Constituent Assembly convened for the purpose of framing the Constitution of Jammu and Kashmir state had completed its task by framing the Constitution for that state. Reliance was placed on the historical background in which this Article 370 was included in the Constitution to urge that the powers under this article were intended to be conferred only for the limited purpose and limited period until the constitution of the state was framed, and the president could not resort to them after the Constituent Assembly had completed its work by framing the constitution of the state. The background or the legislative history to which reference was made was brought to our notice, my lord, that your lordships can, my lord, skip. Then your lordships may kindly see para 5, my lord. So your lordships can, my lord, directly come to 7, my lord. There are, my lord, your lordship gets, my lord, at page 30, at the foot, para 7. There are, may I read? There are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after the Constituent Assembly of the state has passed the Constitution of the state. The most important provision in this connection is that contained in clause 3 of the article, which lays down that this article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as the President may specify by public notification, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such a notification. This clause clearly envisages that the article will continue to be operative and can cease to be operative only if, on the recommendation of the Constituent Assembly of the state, the President makes a direction to that effect. In fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by the President declaring that article shall cease to be operative. Both things are separately mentioned. Neither recommendation made nor President exercised, meaning thereby the President could have exercised the powers even in absence of a recommendation, since there is no Constituent Assembly. I hope, Lord, I am able to make myself clear that till Constituent Assembly was in existence, recommendation. Even otherwise, President could have done it after the Constituent Assembly ceased to exist. On the contrary, it appears that the Constituent Assembly of the state made a recommendation that the article should be operative with one modification to be incorporated in the explanation to clause 1 of the article. This modification in so and so. My lord, thereafter, kindly come to the real issue, my lord, that is 14. There are 13, my lord.
13 or 14?
13, my lord, first. The next point urged was that Article 368 of the Constitution having been applied to Jammu and Kashmir with a proviso added to it, there now exists a provision relating to amendment of the Constitution as applied to Jammu and Kashmir under this article, and consequently, while such special provision for this purpose exists, we should interpret Article 370 as being no longer applicable for amending or modifying the provisions of the Constitution applied to that state. This is what was argued by Mr. Nafede. Now, please see what your lordship say. Para 14. I'm sorry, I'll read it for you. This argument, in our opinion, is based on a wrong premise. Article 368 has been applied to Jammu and Kashmir primarily with the object that amendments made by Parliament in the Constitution of India, as applicable in the whole of the country, should also take effect in the state of Jammu and Kashmir. The proviso, when applying this article, serves the purpose that those amendments made should be made applicable to the state of Jammu and Kashmir only with the concurrence of the state government, and after such concurrence is available, these amendments should take effect when an order is made under Article 370 of the Constitution. Thus, Article 368 is not primarily intended for amending the Constitution as applicable to Jammu and Kashmir, but is for the purpose of carrying the amendments made in the Constitution for the rest of India into the Constitution as applied in the state of Jammu and Kashmir. Even in this process, the powers of the President under Article 370 have to be exercised, and consequently, it cannot be held that applicability of this article, that is 368, would necessarily curtail the power of the President under Article 370. It was also urged that the power of making modifications and exceptions in the orders made under Article 371D should at least be limited to making minor alterations and should not cover the power to practically abrogate an article of the Constitution applied in that state. The submission is clearly without force. The challenge to the validity of Article 35C introduced in the Constitution as applied to the Jammu and Kashmir on this ground was repelled by this court in P.N. Lakhanpal versus State of Jammu and Kashmir. Subsequently, the scope of the powers of making exceptions and modifications was examined in greater detail by this court in Puranlal Lakhanpal.
Yes.
And that is, my lord, which I read, para 4, which, as per Mr. Nafde, was a mere obiter, but the subsequent bench treats it as a ratio, relies upon it, and holds the same thing. But please come to, my lord, now just before one line before paragraph 15. I'm sorry. Para, page 34, just above para 15. This decision, your lordship gets one. How the subsequent 5-judge bench treats Puranlal Lakhanpal, para 4 of Puranlal Lakhanpal, which, my lord, Mr. Nafde contended is a obiter. This decision being binding on us, it is not possible to accept the submission urged by the council. So Puranlal Lakhanpal, para 4 is treated as a ratio. Then 15. May not be of relevance, my lord. I'll just come back to my written submissions, my lord, again. That's on the facts. The rest is, my lord, on the facts of the case. Lord, please come to page 70. Here, parliamentary supremacy.
When zero of your submissions.
My submissions, my lord. That would be combined submission, volume 3. (246), my lord, was applied with some modification, of course. So please. Lord, CO 66, Article 246, which was originally applied in 1954 with only one clause, was applied with modification that Parliament would have the power to make laws in the Union list and some entries in the concurrent list applicable to Jammu and Kashmir. Article 254 was applied in toto, thereby ensuring supremacy of the parliamentary laws in case of repugnancy. Lord, rest, there are some additions, my lord, which may not be of much assistance, my lord. Kindly come to page 71. Once again, the Lok Sabha, my lord, takes up this issue. Where, my lord, those famous words of the Honorable Prime Minister Nehruji, my lord, are reproduced. Only underlined portion. As a matter of fact, as the Home Minister has pointed out, it has been eroded, if I may use the word, and many things have been done in the last few years which have made the relationship of Kashmir with the Union of India very close. There is no doubt that Kashmir is fully integrated. I repeat that it is fully integrated. The provision eroded, most of the provisions are applied according to the situation of the day, and it was awaiting of being extinguished right from 64 onwards. Then, my lord, page 72, CO 69, my lord, this provisions of Article 19, subclause 7 was added, and 35C were extended from 10 years to 15 years. My lord, as I have pointed out, my lord, it came to be kept on being extended till 74. Now, my lord, a private member's bill comes before the Parliament for abrogation of Article 370. Please see, my lord, the debate, the underlined portion only, my lord, for brevity, my lord, so that I don't, my lord, waste more time of your lordships. Inder Malhotra, nominated from Jammu and Kashmir, says this: the people of the state have no special liking for this Article 370, which exists in the Constitution, and we shall be very happy as soon as this is omitted. This was the debate, whether it should be omitted, it should be abrogated, etc. Then Hari Vishnu Kamath, he was also a member of the Constituent Assembly of India. A very leading member, one of the members who contributed immensely. That accession is irrevocable and that integration must come very speedily. If that is accepted, then there cannot be two opinions on the question. That article must go. I take my stand so far as this article is concerned on the firm base that now Jammu and Kashmir state is suffering because this article is there, because difficulties are there by created. If this article is repealed, the state will derive some benefits as other states of the Union are deriving from their relationship with the Indian Union. And therefore, it is from this point, that point of view, that Jammu and Kashmir should be as much a beneficiary of the relationship with the Indian Union as every other state, such as Mysore or Kerala or Bengal or Maharashtra or Madhya Pradesh is today. But, and unfortunately today, Jammu and Kashmir is not a beneficiary of this relationship in the same way and to the same extent as other states. Then, my lord, Shamlal Saraf, my lord, adds, retaining Article 370 by not bringing the state at par with the states in the rest of the country. What has happening? What has been happening? Firstly, there is a sort of insecurity in the minds of the people. Secondly, I will say this frankly, in certain cases, local vested interest, some of them may have been my colleagues, want to have the best of everything and want to take advantage of the present situation. Without bringing any communal, sectarian, or any other view into the matter, I will say that purely from the people's point of view, the people of state have suffered. Once these barriers are removed, once they are allowed to function as any other part of the country, the people will very much benefit. But what was barrier for the people was being canvassed and people were being convinced as a privilege to fight for. Then, my lord, Sri Sonavane in the chair. My lord was from Jammu and Kashmir, my lord, in the parliament. Then, my lord, Sri Sonavane in the chair, underlined portion. There is the non-application of labor laws. In my state, there are lakhs of people working in various forests, handicrafts, and factories, and all the beneficial laws that we have in the center and which are applicable to the rest of the states, as Nandaji knows, as ex-labor minister, that is Gulzarilal Nanda, my lord, became acting prime minister twice, labor minister, should ipso facto apply to that state also. I have myself been a small labor worker, and as a minister, I was in charge of labor also, and I know the feeling of workers in that state. Every time they say, why do you keep this wall of separation? Let us all get tile benefit as the rest of our countrymen. After all, in labor, where people work, there is no question of caste, color, or religion. Therefore, it is equally important, and I would say forcefully, that these things should apply there also. Then, my lord, D.C. Sharma, my honorable friend Sri Gopal Dutt Mengi has said that Article 370 is a wall. I would say it is not a wall. If it was a wall, I could demolish the wall easily and in no time. It is not a wall, but it is a big mountain which stands between India and Jammu Kashmir. Although we have dug the Bani Hal tunnel and we have done everything else, we have not demolished the mountain yet. I feel this mountain should be blasted with the dynamite of goodwill, firmness, and decision. That way lies the salvation of India, and that way lies the good and welfare of the people of Kashmir. Then, my lord, at the foot of this page, my lord, in the debate, Sri Abdul Ghani Goni, the people of Kashmir had decided once and for all, and have decided once and for all, that Kashmir is an integral part of India. Whether there is Article 370 or no Article 370. It is only a provisional provision and a temporary provision in the Constitution which can be removed at any time. But as far as the complete accession is concerned, that is final and nobody can challenge it. Then, my lord, Mansingh Patel on the next page, 76. I am skipping the rest. Lord, Mr. Ghoni, my lord, I am told, was also a member of Constituent Assembly of Jammu and Kashmir. And thereafter, he was a minister also. Then, my lord, Mansingh Patel, we have said before the world as a whole that there is no possibility now of plebiscite and the integration of Kashmir is firm, final, and irrevocable. We continue with this Article 370, thereby showing to the world as if there is still some difference between Jammu and Kashmir and other states of the Indian Union. This kind of maintenance of separate identity of a sentiment, please come to, my lord, page 77, Sri S.S. More, only highlighted part.
But,
I'm sorry, my lord, my learned friend wants me to.
Minister, very interestingly, Mr. Chatterjee refers to the statement of Mr. Sadiq, who was the.
Yes, my lord, I'm sorry, my lord, I would, my lord, rather read that.
Vice President.
I have,
of National Conference. Vice President of National Conference.
yes, my lord. I have in my hand an extract from Hindustan Times dated so-and-so, which reads thus: the veteran founder tighter and National Conference leader, Mr. Sadiq, today confirmed reports of lawlessness and corruption in the administration of Jammu and Kashmir. Mr. Sadiq, I'm told, was the Honorable Chief Minister then.
He took over after Bakshi government.
Yes, madam. Mr. Sadiq, who is the senior vice president of the ruling National Conference, declared in an interview that abrogation of Article 370 of the Constitution was essential for the restoration of normalcy in that state. I maintain that it is today more imperative for the restoration of normal conditions, for the upkeep of democratic life of that state, and for greater cohesion, both of the people of Kashmir and India as a whole. We should not delay any further. What has happened since 29th of November 63 till today, which necessitates that there should be any going back on the solemn declaration that Article 370 must be abrogated and it is essential for restoration of normal conditions in that state. What is heading of this chapter, that chapter? It is in part 21 of the Constitution, temporary and transitional. Therefore, Article 370 was never